Alrighty, folks, this is George Simons. I'm founder of Solo, and we are here with the Debt Hotline. We have my friend Yale Levy with us today. Yale, can you tell us a little bit about yourself?
Yes, good morning, or I should say good evening, everyone. My name is Yale Levy. I was a collection attorney for 20 years. I owned a law firm based in Ohio that did work in Ohio, Kentucky, Indiana, Virginia, and Maryland. I sold my practice at the end of 2023. Thought I was retired for the rest of my life. And then George contacted me, said, hey, needed some help, and he hired me. And before I knew it, I had a job. And I've been with Solo since September 15th, 2024. It's been a great time.
Fantastic. We're very lucky to have Yale Levy on the team here at Solo. He's an expert on debt collection, understands what consumers need to do, what collectors need to do to get that resolved. Alrighty, folks. So today we're talking especially a little bit about, can I negotiate my debt after a judgment? What's the quick answer on that? Can you negotiate a debt after there's a judgment on a lawsuit?
The quick and easy answer is yes. You can always try to settle a debt at any time throughout the process. Unfortunately, the sooner you try to settle a debt, the better the deal you get. The later in the process it goes, the harder and harder it becomes to settle that debt, because so much time and effort and court costs have been spent to get to that judgment. It is now going to be more expensive for the ordinary consumer to have that debt settled for something that could have been settled for maybe half that amount if they did it earlier in the process.
Right. Think as expert negotiators know, everything is a negotiation,
Correct.
right? Even buying bread at the grocery store can be a negotiation if you really want a deal.
The most difficult time to negotiate a debt after a judgment has been obtained is when they have a bank attachment or a wage garnishment already filed. So the collector or law firm or lawyer that has the debt knows that they're going to get paid basically 100%. And in those instances, it becomes very, very difficult to get them to take something less than the full balance, because they've spent so much time trying to get to that spot. And now it's going to come out of your paycheck or your bank account, and they have really no incentive to take less.
Right, for sure. So what is the incentive? Like, what is the carrot that a consumer can give to a collector if there's already a judgment? Like, what's the carrot they can give to get a deal
So,
done after a judgment?
yeah, if they haven't obtained where you work, or they haven't figured out where you bank at, the carrot still is, would you rather have money now than maybe have it down the road? Um, some people you can't find where they work at. Some people you can't find where they bank at. So yes, large, there is a risk there that they won't be able to find where you work at or where you bank at, and they would want to take something rather than nothing. So if you work at someplace small, like a pizza parlor or something that's kind of off the grid, it's a little bit more difficult for that law firm or collection agency to find you. But if you work at a big company like Walmart, Joann Fabrics, Target, that report to all these bureaus, there's a good chance that they'll probably one day find where you work at and use that information to start a wage garnishment against you, which is a pretty life-changing event, because a wage garnishment varies from state to state. So I'm going to be generic here. I can't tell anybody about their specific states. But once a wage garnishment is filed, the creditor or the plaintiff gets to take up to 25% of your take-home pay. So you're barely making ends meet, and now you get hit by a wage garnishment, and all of a sudden your $500 paycheck becomes $350, not $500. And now you have to try to make ends meet with $150 less a pay. Bank
Right.
attachments go the same way. No bank attachments. Sometimes you have money in the bank, sometimes you don't. It all comes down to timing and how lucky they are. So bank garnishments or bank attachments, as they are called in Ohio, is kind of a hit or miss. It depends when you hit. Guess what? If you hit a bank attachment or the bank at the end of the month, before you pay your rent, before you pay your car payment, before you pay your mortgage, they might get a lot of money. If it hits after that time, they might just get a little bit of money. So we call those things involuntary payments, because instead of you being in control and being able to decide how much and when, or at least come to an agreement with your collector about how much and when, that's so much more preferable than these surprise attachments or garnishments that takes money out of your check without you knowing it. And then you don't have any say in how much is taken. They just take what they can.
Right. So that is the quick rundown on whether you can, negotiate after you have a judgment on your debt. Short answer, folks, is yes. And folks, we reserve quite a bit of time here for questions that you have live. So if you have a question, put those into the chat, and we'll be trying to get back to you there. We also have people who write in questions before the show. Also have some people who do audio for us. A lot of people are leaving voicemail on the debt hotline, so you can call in and leave your own question on the hotline, and we'll get to that on the show. So we have the first question here coming up from Kevin. I'm going to go ahead and play this clip.
I have a two-part question regarding settling a debt during the lawsuit process. And it's not my first time going through the process, but it's been a while. So I'm aware of a few things. Currently, a firm in New York is suing on a $13,000 debt from Lending Club. And I responded to the lawsuit back in January. And
Yes, that's the first bit there, right? So he's getting sued, $13,000 debt, Lending Club, getting sued in New York.
I haven't heard back from them since. And no changes online with the lawsuit. I live in New York. There's a 3-year statutory limit. I'm in year 3, next year will be year 3. My question is, once they file the lawsuit, does that pause the statutory time? And if it does, how do you unpause it so you can go back to statutory time being counted? Because once 3 years goes by, I don't have to pay it in a sense. I can just say you're out of your time limit to sue me for it. And 2, if I do go ahead and choose to settle it, I was going to go in at 20 cents on the dollar. Reason being, I can always do a bankruptcy possibly. And also there's so many debts, they're going to be finding it hard to get blood from a stone. So that is my question. How do you calculate the statutory time? And do you see an issue with going in at 20 cents on the dollar? And it's with velocity.
Alrighty, so Kevin is wondering whether, how statute of limitations is calculated in New York. Also, if you can get blood out of a stone, right? So how low can you settle? What do you think, Yale?
Yeah, so boy, what a great in-depth question that Kevin had. So his first question is, once they file the lawsuit, does that stop the statute of limitations? Again, I am not a New York lawyer. I am a lawyer in Ohio. But hypothetically, since I cannot give legal advice to anyone here, filing the lawsuit in most states, if not all states, will pause the statute of limitations. So that means that the statute stops during the lawsuit period, and if judgment is granted, the statute of limitations is now off the table because a judgment has been granted adjudicating who is owed the money or if not owed the money. So unfortunately for Kevin, the statute's not up. Sounds like they filed timely according to the data that he provided us. And unfortunately, that's the situation. His second question was, should I start at 20%? Again, it is everybody's ability to start wherever they want. And creditors and law firms and collectors will look at your unique circumstances to determine what you can afford to pay. There are some instances based on the hardship that Kevin has, depending on his age, his income, and his assets, they might accept 20%, albeit unlikely. We do see a lot of Velocity accounts on SoloSuit. Velocity is a good company. They're an honest debt buyer, but they do sue people frequently to collect money that is owed to them and debt that they have bought. Usually we see settlements in the 60 to 80% range, but again, every circumstance is unique. If you have very little assets, if you don't own a house, if you're over 70 and are no longer working and you're living on Social Security, they might be very willing to take 20% because that's probably better than they could get otherwise. So there's a lot of variables. Every situation is unique and stands on its own legs. So I have seen some creditors and collectors in my day when I worked in collections even walk away from debt saying there's nothing we can get. So that does happen. But they do spend a lot of time looking at the debts that they want to sue on, because for them it's an investment. They have to pay the court costs up front. So there is some skin in the game for these debt collectors, these law firms, these debt buyers, these creditors. So they really don't sue everything. They just sue the things they think are collectible.
Right. Filling in some details for you there, Kevin. My understanding is the statute of limitations in New York is 6 years, not 3, under the New York CPLR Section 213 is what we're seeing. Solo does have a great statute of limitations calculator you can use. So you can search statute of limitations calculator, Solo, that'll come up on our blog. You can check that out and punch in your details there to see if the statute of limitations has expired. And the question is, are you actually a stone, right? You can't get blood out of a stone. Are you actually a stone? I don't know. We'll find out. I think the collector is suing you because they have some score, like a collectability or solvency score, that's indicating to them that you likely have some ability to pay that debt. So 20 cents on the dollar isn't something that we see very often in the lawsuit because they've accrued so much cost getting to the lawsuit stage. You might have been able to get that before a lawsuit. Now the lawsuit's happened. What we see most often is like a 70% to 80% settlement after the lawsuits begin. Right. So let's see. Let's get on to the next question. We have one from Matthew. I'm going to pull up that clip and play it.
Hello, I'm currently in a lawsuit with Velocity Investments for about $5,000. I'm in Kansas. I was served last October, filed my answer with SoloSuit right away, had a pre-trial Zoom court in January. Plaintiff asked for continuance to provide discovery, had another pre-trial Zoom in March. Same thing kind of happened. They wanted more time. Judge said okay. And now next court date is this coming Monday. Kind of wondering how to proceed from here. I still have not received ever any correspondence from Velocity Investments. I haven't received any of these documents of discovery or a settlement or anything. No phone call, email, mail. Just how aggressive I should be at this next trial date if they still don't have anything. It's been over 6 months. Should I just tell the judge that I think they've had enough time? Should I even ask for the case to be dismissed at this point? Just kind of wondering how to proceed from here and how forward to be at this next court date, since it seems like nothing's happening. Thank you.
Alrighty, that's our question from Matthew. So he's wondering what to do in this lawsuit with Velocity that is ongoing. What do you think, Yale?
Matthew really gave us a great detailed synopsis of what's going on. I'm surprised the judge's been so lenient on the plaintiff's attorney. Again, I don't work in Kansas. I am not a Kansas lawyer, but what I would suggest hypothetically doing is he should say, Your Honor, this has been the third pretrial. I haven't received anything. It's been 6 months. I think it's time for the opposing party, the plaintiff, to either, make a move or dismiss the case, because they seem that they're dragging their feet, and I keep coming to court, missing my job, and this isn't fair to me. So that's what I would do if I was Matthew. Again, you need to stay in court. You need to stand up for yourself and advocate for yourself. There's a couple ways to do that. You could hire an attorney to do it. You try to find legal aid to help you, or you got to do it yourself. So the best thing is that everybody in this call should listen to is Matthew went to all these court hearings. He didn't skip them. He did not show up. He came. Let me just tell you all, if you don't show up for these hearings, there's a chance that the case could be ruled against you because you failed to appear. So it's very, very important to show up for these court hearings, these case management conferences, or these pretrials. Because if you don't show up, then the court says, boy, they're not interested in getting this settled or resolved, and there could be a judgment awarded against you. When you receive your notice in the mail, sometimes it does say at the bottom, failure to appeal may result in a default judgment or a court judgment being awarded or issued against you. That is not there just for the hell of it. They're giving you that notice to put you on notice that that could happen. So please go to court.
Right. And Matthew, worth pointing out, right, if you owe this debt, if you're aware of the debt, if you owe some portion of it, even if you get the case dismissed, right, you could ask the judge to dismiss it for lack of prosecution. Even if that occurs, you still will owe the debt, right? You'll be winning you'll essentially be quote unquote winning on a technicality or getting the case tossed out of court. It's not exactly the same thing as winning or having the judge say that you don't owe the debt. So they could still try to collect on it outside of court if they wanted to. So best option for you if you owe a portion of the debt is just to try to contact them and make a deal for settlement. Solo has a good relationship with Velocity and other collectors that collect for them. So you can always make an offer to them on Solo Settle, right? You can see what kind of offer you can get on Solo Settle if you just punch in the information right now on solosuit.com/solosettle, and you can make an offer and then start making payments on the debt. That'll improve your credit score and really improve your financial position long term. Okay, we've got a live question here from Linda Sotomayor. I received a judgment for eviction, but all paperwork was sent to my last address. I didn't get a chance to go to court. After a judgment has been issued, can I request a hearing? First question I have for you, Linda Sotomayor, is, why don't you ask your cousin, Sonia Sotomayor, justice in the Supreme Court, right?
Yeah.
That name doesn't get around that much. But glad that you're coming to the debt hotline to get some
Yeah.
tips here.
So Linda, again, I don't know what state you're in. I cannot give you legal advice, but I'll tell you what I would do if it was me. Yes, I would contact the court, do a motion to set aside the judgment. One of the seminal things that has to happen for a judgment to be issued is that the defendant needs to have due process. And to get due process, they need to have notice of the court hearing so that they could show up, defend, and appeal. If it was sent to an old address and you did not have knowledge of the complaint being filed against you, you need to stand up for yourself. You need to go to court, and you need to have the court set aside that judgment. We do have a product called Solo Pilot on SoloSuit's website, where you can use AI to help you create a motion to set aside judgment. My recommendation to you is twofold. Just my recommendation, I'm not giving you legal advice, is one, be specific as possible about dates and times of where you lived and when, so that they could see that service was made at an address where you didn't live at that time. And I would recommend that you attach an affidavit to the motion, kind of swearing out that you lived at this address at this period of time, you moved on this date, and that after that date, you lived at this other address for this period of time, and that you never received service. That affidavit would really help support your motion to set aside the judgment. I would also request a hearing be held so that you could go to court, plead your case, explain to the judge that you never received that summons and complaint for the amount owed. And I think all those things would put you in a pretty good position to get that judgment vacated.
Yeah. Linda, it seems terribly convenient, or at least ironic, that you were served documents for eviction in the wrong place, right? This is for an eviction situation. Seems like whoever's trying to evict you would know where you live. So seems kind of bizarre. You definitely do a motion to set aside judgment. And just real quick, looking at what that looks like. So it's basically just our AI document generation tool on SoloSuit. So you go to solosuit.com, click generate a document, get started, and then you have to sign in, which is free to make an account. And then let me log in here real quick.
You don't want to show everybody your username and password?
Not this time. Not this time. Let's do that now that we're in the thick of it. And you can confirm your email address, and here we go. And you can select from a very long list of documents here, and you can choose the motion to set aside judgment, like I just did there, and then you can continue. And it's a very low cost option for generating awesome legal documents. People love this tool, they use it all the time. And there's that. Okay, looking on to the next live question. So we have one question here.
Yeah, why don't we do Bruce's, the one on top? Can I read it for you? Yeah.
Bruce's? The in the show notes here? Yeah, go
So
ahead.
Bruce has, I've been sent a notice for my second hearing. Can I request a continuance since me and my creditor are working on a settlement? Yes, you can do that yourself, Bruce, or you could ask the lawyer that you're working with to do, that represents the creditor, to do that for you. There's no need to go to a second hearing if you guys are in the midst of settling or trying to settle that account. It'll be helpful, I think, to you to save time, not miss work, and try to get the case settled. I hope that helps, Bruce. This another one, George, a video.
This is a video. They're trying to sue me for the remaining balance on a truck that was repossessed. The court date tomorrow morning at 8 o'clock in the morning. Paperwork, guys can get a look at it. Maybe you can give me some advice on what to do, what not to do. Supposed to be there tomorrow morning, 8:45 in the morning. To show me paperwork, summons of it. Okay.
So I'm sorry the man didn't leave his name, but he said his truck was repossessed and his trial is the next day. Well, guess what, folks? Trial the next day doesn't give you very much time to get a debt settled. What I tell people all the time, and I'm on the phone all day long, is the trick to settling your debts is one thing and one thing only: communication. You need to communicate with your collector either by picking up the phone, hiring a lawyer, using legal aid, using SoloSuit, using another service, but you need to communicate with them. They send you these things because they want to get your attention and they want to get these cases settled. It is better for them. It is better for you. Let me tell you, an 80% settlement, which means you pay 80% of the debt, will be much better for you than having a judgment taken, having court costs and interest start accruing, and in 5 years, that $100 debt becomes $150 instead of $80. So you need to communicate. Yes, you need to stay on top of it. You can't wait to the day before the trial to start asking for help. That doesn't work. You need to do it as soon as you get the summons and complaint. You need to pick up the phone. You need to look at SoloSuit. You need to call a lawyer. You need to go find legal aid. You need to find a way to communicate with that collector or that law firm or that creditor so you get these cases settled. They want to settle. You want to settle. Everybody wants the same thing, and a quick settlement as quickly as possible. So again, there's so many ways to do it. Go on, George. Show them how it works.
Yeah, but definitely the easiest way to settle is just go on SoloSuit.com, click settle a debt, and you're going to be put right in here. You just give us some basic information about your lawsuit, and then we'll help you get that thing settled real quick. We'll show you what kind of deal you can get with the collector, and you can get this thing wrapped up very quickly. Oftentimes we get settlements done in just a few
For sure.
days.
Hey, Kelsey
All right.
Perry, to answer your question, do you suggest filing an answer with Solo or doing the settlement offer with Solo first? Well, ideally, if you have time, you should try to get it settled before an answer is filed and resolved. But if you don't have time or you're running into a time crunch, you need to make sure you understand your state's time period for filing an answer after service. SoloSuit has great resources and educational material to tell you, based on your state, how soon you have to file an answer. Some states are 20 days, some states are 30 days. In Ohio, where I'm from, it's 28 days. So you have a specific static period of time to get an answer filed. If an answer is not filed, there's a chance a motion for default judgment will be granted against you. So yes, if you have time, Kelsey, I would try to reach out via SoloSuit or call them or hire an attorney and try to get the case settled before that answer date is due. And if you could do a lump sum, they might be willing to even dismiss the case. So time is of the essence. That's why I keep saying communication and acting quickly as possible when you get that summons and complaint.
For sure. And so you can use SoloSuit software to get that answer filed. Sometimes people can get it filed in just one day. Sometimes it takes up to 8 or 9 days to get the answer filed, so you don't want to cut things too close there. Also, you can also use a motion to extend time, which you can generate with the SoloSuit document generator. And you could file that as well, asking to push the deadline to respond back 30 days. Is a pretty standard request and oftentimes approved by the court. We have a question from somebody who wrote in to the debt hotline. Going to go ahead and read that here. This is the question from Jessica. Jessica, if you're on the show live tonight, just let us know in the chat. Love to hear some more from you. So Jessica says, my name is Jessica, and they said I owe $1,600 and some change, or originally the debt was only $1,092. I'm assuming once the judgment was made and decided, which was 2013 and decided in 2015, I was incarcerated. Okay. So looks like she was sued for $1,000 debt, which might not be very much for some people, but for other people, it could be a huge amount. And it looks like about $500 was added in additional fees. And at the time she lost her lawsuit, it looks like she went to jail for some reason. You're definitely wondering, what happened that you went to jail, and too bad all this, stuff happened all at once on you. I just found out about this judgment on April 4th this year. I put in a motion, so that's about 10 years later, right? So like 10 years later, she finds out about it. I put in a motion to set aside judgment, showed up to the proceedings, supplemental on the 25th, and it was a joke. The attorney representing the plaintiff, which is LVNV, continued because there was not a hearing to set aside default judgment, and I highly recommend that I file another motion to set a hearing for that. Okay, so it looks like she showed up to a hearing, but it wasn't necessarily talking about the motion to set aside. So she went back on May 30th to talk to another attorney representing LVNV, and he said that 30 a little bit fuzzy on what exactly Jessica's saying here, but she says he said 30 other debt collectors, and they should have a hearing set before then for the motion to set aside judgment. She's asking, is this normal? A little bit fuzzy here. I expected to talk to a judge, and it was some random attorney instead of an actual judge. I just want a chance to defend myself because I believe the actual debt had passed the statute of limitations, and I was never properly served. Then they waited 10 years to come at me again. Thanks for your input. What should I do?
Jessica, what elaborate story, and I can't believe that you have a debt from 2013 that is still following you, but that can happen. They are able to revive and continue to renew judgments so that they do not go dormant. Yes, I think you need to keep advocating for yourself. You need to keep going to court. You need to keep filing motions to have that judgment vacated. You need to explain to them, as I told Linda, in your motion, explain to them in detail why service was bad, why it was out of statute, and if you could figure out how to do an affidavit, back up those facts with an affidavit that explains one potato, two potato, why you say what you're saying is true. Go to a bank and have it notarized, attach it to that motion. Do not give up. Do not quit. You need to continue to advocate for yourself, beat your own drum, and do what you can to get this judgment vacated if you truly believe that they did not have proper service on you and or that it was out of statute at the time that they sued you. But we have lots of resources on SoloSuit.com. We have lots of blogs, articles, YouTube videos that should help you understand what you need to do if you need any additional help. I wish I could give you more information, but I haven't seen your paperwork. No, I'm totally clear on exactly what the issues were. But again, this is the problem when a default judgment is issued against a consumer. A $1,092 debt becomes $1,600. That's about almost a 50% increase of that debt amount. That's why it is in everybody's best interest. Don't let them get default judgment. Stand up for yourself, communicate. Use Solo Settle, use an attorney, find legal aid. Go to our website. We have lots of resources, including document generation abilities to help you prepare the motions and other documents that you need to protect yourselves.
Right. Yeah, Jessica wrote in on the chat saying that she is here. Jessica, if you could let us know what your income position is like on this, in regards to this debt. I mean, it might be a situation where it might make sense just to try to pay off this debt pretty quickly, right? Like if you have a $1,600 debt that's outstanding and it's like 20 years old or thereabouts, at least 10 years old, he might be willing to take a pretty good settlement deal on this thing, right? He might be able to wrap it up for 1,400, maybe 1,000, maybe even less, maybe $800 at this point. And maybe you could do that in like three payments over 3 months, right? 3 payments of $400. Then you could get this thing fully behind you and totally out of your way, right? Jessica is saying she brings in a little over 2,000 a month. Okay, so thanks for letting us know. So you're doing like so that's like 25,000 a year. Oftentimes we see that people get sued for about 80% of their monthly income is like an average number, right? So you're being sued for about 80% of your average income, monthly income. So that's probably a pretty significant thing and might put you in a pretty bad position trying to pay that off in a lump sum, depending on what you have in the bank account. Yeah, do you have any like assets available that you could use like to pay off the debt faster? A question I'd have for you. If not, maybe we can get on some monthly payment plan to get the thing wrapped up. All of that said, right, lots of questions here, right? Was the statute of limitations essentially less than $170 left over after bills? The collector might very well take a monthly payment of $100 on the debt in this position, which would get you paid it off. And when they do that, they'll usually stay the interest on SoloSuit. It's usually a required term is that they stay the interest. Yeah, do you know if the collector will usually stay the interest on a post-judgment settlement?
Yeah, it depends on the client and the law firm that has sued her. I see she has no assets and she looks like she has pretty low income. It's a really good conundrum about the place she's in. I think she's doing the right thing. Jessica, keep up the hard work, keep going to court, keep getting the attorneys to come to court. That every time they do that, you get a little bit closer to maybe getting out of this. But it's going to be a long road to hoe. I see CJ had a good question, if I may, George. Is that okay to move on?
Let's keep on Jessica. I have a few more thoughts here, and we can go to CJ to wrap up. Jessica, yeah, further thoughts, right? So you filed a motion to set aside judgment, but it's 10 years after the fact. A court probably isn't going to accept the motion to set aside judgment, no matter what the reason, after 10 years. So that's not likely to happen. And then as far as like the commotion at the court, right, it seems like you're pretty bothered with how the hearings are proceeding. We see that situation pretty frequently, right, where consumer is going into the court. Sometimes it can feel but usually the court's just kind of operating pretty. My experience is kind of a result of just the consumer being like an outside player, not really knowing exactly how things work in the court. Maybe you've gone through the court system before. Maybe you're somewhat familiar with it, but in these situations, oftentimes things can just progress normally. So I wouldn't be too suspicious that something weird is happening here. The attorney with LVNV is like licensed by the bar, right? The bar is regulating what they're doing, overseeing their actions, making sure they aren't doing anything sketchy. And the judge, of course, will be a legitimate attorney, most likely depending on the state. Sometimes like Texas or Arizona have pretty young non-attorney judges in their small claims courts. And then last thought here is just pointing out that the collector will be able to infinitely renew the judgment, right? Now they have this judgment against you. They can renew that in most states pretty much forever, right? Usually it comes up every 10 years for renewal. That's why they sued you in 2025, or that's why they came after you again in 2025, is because the judgment was coming up for expiration and they probably decided to renew that. So if you want to get this thing behind you, protecting yourself in court and trying to make a settlement deal with them is probably the best way to make that happen. And just try to figure out what you can afford on that. So it's definitely not something more than $170 a month, and try to make some little payments to get yourself out of debt and get back on track. We're sure that you can do it. All right, Jessica. All right, Yale. Last question here with CJ.
I'm gonna do a couple quick ones real fast. So Maylee says, if a judgment is made to garnish any income, can I still file for bankruptcy? The answer would be yes. Enrique, should you settle before even if not knowing if the lawyer suing me owns the debt already? Answered with SoloSuit for court response. It's kind of a compound question. I'm assuming he meant to say, should you settle before even knowing if the debt is owed? No, you should actually ask the lawyer or the collector to prove that you owe the debt. But once they do show that you owe the debt by showing you evidence via credit card statements or something else, and it's usually attached to the complaint, then you should work very hard to communicate with them to settle the account. CJ, you say you settled with portfolio recovery in January for a reduced amount, and they filed for an MSJ in March for the full amount. Were you making your payments pursuant to the January settlement that you entered into? Maybe you defaulted on those, and that's why they decided to file for MSJ in March. If you did not default, I would show that to the court and tell them, hey, I have this agreement here. Why are they filing an MSJ if I'm abiding by the terms of the settlement agreement that I had with portfolio recovery? So there's kind of issues there. I don't think you need to file a motion to dismiss. Hypothetically, I would say I would file a motion in opposition to summary judgment, citing that agreement that you have with portfolio recovery, hoping it's in writing and that you can attach a copy of that to that motion contra or motion in opposition to the summary judgment, and explain to the court, hey, don't grant me motion for summary judgment, we've settled this case. Typically the judge or the court provide you with some time to get the settlement made and have the case dismissed. So that would be much, much better for you. Boy, there's so many questions. I wish we had more time, but this is very complicated stuff for everybody. The legal process is not easy, but the one unifying factor is communication. You need to not stick your head in the sand. You need to reach out to your collector, your law firm, the creditor, talk to them, use solo settle, use a lawyer, but the communication is the key to getting these cases resolved. Everybody wants to settle. That is the ideal settlement, is a quick and fast settlement for something that the consumer can afford and that the creditor can accept.
Bingo. Yeah, you nailed it. That's a good one, right?
Right.
Yep, something, right? We're all trying to find something that the consumer can afford and that the collector can accept. All right, folks, this is the Debt Hotline by Solo. You've been listening to me. I'm a founder of Solo. My name's George, and Yale Levy has been our guest today. Thanks so much for showing up. We're doing the show every week on Wednesdays most of the time. So tune back in next week. We're giving you tips on not only how to respond to a debt lawsuit, not only how to resolve or settle a debt lawsuit, but also helping you out with things like evictions or general financial tips, right? If you want to find out more about how to improve your credit, how to improve your net worth, feel free to call into the debt hotline, leave us a voicemail, and ask your question. Alrighty. So we'll see you next week here at the debt hotline. Take care.